My name is Melinda Medor.
I'm sorry.
That's quite all right.
Beg your pardon.
Quite all right. And I am a member of the Weakley County Bar here on behalf of Mr. Christopher Thompson, who was convicted a couple of years ago on a negotiated plea to second-degree murder, for which he received a 20-year sentence. I'll go over, well, this is a pretty straightforward case, and I'm sure you all have read the briefs. You know that there are really only two allegations here. One is ineffective assistance of counsel, and the second is an involuntary plea which occurred as the result of involuntary assistance of counsel. The facts in this case were unusual and not pretty. There was a young woman living in what I have described as an encampment on a little bit of property alongside Garrett Lake in Weakley County, which is close to Palmersville. She lived, there were two actual places to stay on this little bit of property. There was a trailer and basically a tent, and they apparently lived in the tent off and on all year round. In addition to this young woman, my client lived there with his wife and with his brother, who was the father of this young woman. Both the father and the daughter were disabled. His was a physical disability. Hers was a mental disability. She was mentally challenged. Their living circumstances were unusual in that they were all living together in this very small trailer part of the time, and then sometimes one or more would go out to this tent. And this happened in January of 2022. The facts as they were developed show that all four of these people were in the trailer on the night that an argument broke out between my client's wife and the victim. So aunt and niece are in a fight. From the records, it appears that them getting into these arguments was not unusual. The living conditions, I think I could generously describe as squalid. They did not take particularly good care of this young woman, but her father was there, her aunt was there, and my client were all there with her in these circumstances. They all lived pretty much the same. At some point, apparently on or about January 20th or 21st of 2022, the wife and the niece got into a fight. My client attempted to break up the fight, and this, of course, is based upon his testimony and her testimony. In breaking up the fight, he pushed the victim to the floor. She struck her head on a metal box and was knocked out. That is his testimony, corroborated at least in one statement by the wife. My client says that the last time he saw his niece, she was still breathing. She apparently lay in the trailer overnight, having difficulty breathing, but making sounds that led them to believe she was snoring. When they woke up the following morning, she was dead. Now, the wife later came up with a slightly different set of facts, But that is the set of facts that is consistent between the husband and wife. The girl's father never made a statement. To my knowledge, he certainly didn't speak to defense counsel. I'm not sure whether he ever spoke to the state or not. The morning after this happened, the wife and my client's brother got in a car and drove to Georgia. Just disappeared. My client left behind with the dead body of this young woman, takes it upon himself to bury her on the property. He goes out and rents a tractor with some sort of a backhoe, brings it out to this lot, buries the victim on the property. He has admitted to that. He did not, however, admit to killing Ms. No intentionally. Her name was Mandy No. Initially, this people I don't think even realized they were living out there. And the event did not come to light until almost 2 weeks later, when the wife, who has come back now from Georgia, goes to the sheriff's department and files domestic assault charges against her husband. She says nothing about Mandy No. She just files assault charges of her own against the petitioner in this case. Again, nothing is said. She goes back to court a few days later and begins to rant, if you will. As the public defender who was in the courtroom put it, she was acting crazy. And when they finally were able to figure out what she was saying, the judge told her she needed to be talking to the sheriff. She went next door to the sheriff's office and told them that there was a body buried on their property and that she believed that her husband must have killed her. He was already in jail on the domestic assault charges, and so they went in and interviewed him in the jail without counsel. He did sign a waiver. Then the public defender, Joe Atnip, at the time, called one of his assistants and said, will you go down to the jail and meet with this guy? They are trying to find out where the body is. And you need to help them sort of run interference between him and the law enforcement authorities to try to find the body. And that's what he did. And when this young defense attorney, James Washburn, was called to the stand during the post-conviction hearing, he actually said, they told me he had confessed, and all we were going to do was go look for the body. Now, the important thing for the court to understand is my client never confessed to the murder of Mandy No. He said he buried the body. He acknowledged that he did. But what he said was, the last time I saw her, she was still alive. I did knock her down, and I did it accidentally. Now, you may or may not believe that. A jury may or may not have believed that. But it does present the outline of a defense that the public defender could have followed. There were a number of peculiarities in this case that were never followed up on. That is one of them. There are two other people in that trailer who absconded, who left and went to Georgia immediately after it happened. Those people could have been just as responsible, if not more so, than my client was. One of them, the wife, was ultimately charged with aiding and abetting, and I believe she got an 8-year sentence. Although the public defender, when he testified, could not even remember what her sentence was. The girl's father wound up out in Oklahoma and nobody ever talked to him. All of that looks very suspicious to me. And as someone who has been both a prosecutor and a defense attorney over the years, I can see how a defense could have been made that they were responsible for the murder, not my client. No one ever really followed up on that particular defense or a number of other possibilities. My client said, "I didn't mean to kill her." That sounds like manslaughter to me. Again, the defense attorney, in this case, who is now the public defender in Weakley County, Bill Randolph, testified repeatedly during the hearing. There just wasn't a defense. Somehow, because my client had taken responsibility for burying the body, that seemed to be the end of the discussion as far as Mr. Randolph was concerned. And he even said as much during his testimony at the post-conviction hearing.
Well, you state on page 7 of your reply brief that there were substantial defenses available. You've listed 2, and I went back and I read your initial brief again. But if I have it correctly, you've said the first one, 2 other folks did it, and then the second is manslaughter, reduced sentence. So let's take the second one first. The defense attorney in this case actually negotiated a plea to a lesser charge, didn't he?
Well, we don't know that it was actually negotiated. The state said 20 years. 20 years.
Did he plead guilty to second degree?
He did.
Okay. And to a 20-year sentence. And one of your listed defenses is it could have been manslaughter. Is that right?
Correct.
Okay. Let's go back to the first one you went over, but these other 2 folks could have been to blame. Did your client or anyone else provide proof to the lawyer or the investigator that these folks were actually responsible? That they committed and killed this woman?
I think he discussed that with his attorney. But he's in jail.
Did he say it in his statement to his post-arrest statement?
No.
Okay.
I believe at that point, and look, a lot of this is speculation. I acknowledge that. But if I'm in his shoes, I'm not going to tell the police any more than I absolutely have to. I'm not going to point the finger at 2 other people right off the bat. He may have wanted to protect them. It was his wife and his brother, after all. But that doesn't mean that at some point the defense attorney might not have had a heart-to-heart talk with his client and said, "You're going to have to point the finger elsewhere." The problem is none of that was ever done. There's just this, look, public defenders don't get to choose who they represent. This is not a nice set of facts. My client is not an easy person. As the record shows throughout, he argued with his attorney. He wanted him to do things the attorney never did, and maybe they weren't valid, but I'm using that as an example only to say this is a very difficult man to deal with. And what comes through the record to me is, let me just get this case behind me. He will take this if I just keep at him. He needs to take this 20 years. Here's a man who went for over 2 years in which he never once confessed. He maintained his innocence the entire time. He said, "I'm not guilty of this."
Until he said, "I'm guilty" in court.
Until he said it in court. And at that point, the pressure, there's no known defense. And the way the defense attorney keeps presenting it is, you can take 20 years or go to trial. It's almost as though he's saying to him, "You're on your own, bud. You don't take this deal, you're on your own." No defense strategy ever developed. And the defense attorney said that to me. I didn't have a defense. I didn't have a defense. There was no defense.
Well, sometimes the defense isn't some sort of grand strategy, but it's just putting the state to its proof. It sounds like the proof here is somewhat circumstantial. You do have the partial admission there, but without calling it some sort of strategy, I mean, isn't that in itself a strategy, just going to trial and testing the state's proof?
Well, he might have explained that along with the weaknesses, but if you go back and you read the letter that is in the record, written by the public defender to this defendant, he says to him, he gives him no hope, absolutely no hope that they would be successful at trial. None.
Was there?
Actually, I could see it, and I wouldn't say that to you if I didn't honestly believe it.
Would you bet 31 years on it?
It's not my call to make, though. It was this defendant's. Would I risk
Was
it?
that-
Probably not.
Was that ferreted out and clarified to him during the plea colloquy?
Yes, and
Is that in the record?
Mr. May has noted that I did not include the plea colloquy. I know Judge Parham well enough to know that he did exactly what he was supposed to do. I cannot say that he was not told exactly what he should be told. But here's the other thing. Because I have prosecuted down there, over there, I know the attorneys. When I was a prosecutor in Obion County for 5 years, the public defender, Damon Campbell, anytime he had a defendant who seemed to be,
Down to 1 minute,
okay,
just to let you know.
I've talked more than I thought I would. Anytime he had a defendant that was kind of squirrely about whether he wanted to plea, or if he had been difficult and he thought there might be some ineffective assistance argument made later, he would do his own questioning of the defendant in front of the court. Because keep in mind, the judge doesn't know that any of this is going on. The judge doesn't know that my client was still contending he was not guilty up to minutes before he stepped to the podium. The prudent thing to do, arguably the effective thing to do, would have been for Mr. Randolph to say on the record, are you satisfied with my representation of you? Are you sure you want to enter this plea? You told me 15 minutes ago you were not guilty. I've seen it happen over and over. It didn't happen in this case, and Mr. Randolph admitted that during the hearing.
Thank you, ma'am.
Thank you.
General?
It's like Groundhog Day, just a day later.
We've determined that Judge Sword has found the most expensive stopwatch in the world. It's doing a great job, though.
May it please the court, good afternoon, Kirby May, on behalf of the state of Tennessee and the Attorney General's office. This court should affirm the decision of the trial of the post-conviction court denying the petition. One thing I noted on my friend on the other side's recitation of the facts of what led up to the arrest and then prosecution. None of that's in the record. None of it. We can glean a little from the post-conviction hearing, but we do not have the plea colloquy, which would have been oftentimes a stipulation of recitation of what the state would have presented. We do not have any of that in the record. And even more so, if the defense wanted to assert, again, a post-conviction, the defense has to prove by clear and convincing evidence. And if the defense wanted to assert that it wasn't a strong case, or my statement was different than what my trial counsel indicated, or what was discussed, none of it was presented at the post-conviction hearing. Not aspects of the investigation, which would have potentially shown other avenues for the defense, not the defendant's statement, not the testimony of the defendant did not include, beyond a broad statement of that wasn't what I said, any showing of the statement or introduction of the statement. What we do know from gleaning from the post-conviction hearing, because that's all we have. And that's, is that the co-defendant, the defendant's wife, reported the domestic violence incident, and then and vague, and then reported the missing victim here, the vulnerable adult. And based on that, the investigation started, and the defendant was interviewed. We do not know the content of his interview. He stated at the post-conviction hearing, I just pushed her, and I intervened, but however, again, vague reference to the wife's statement. Initially, the wife stated that the defendant was attacking the vulnerable adult victim. And later she, I think, recanted a little bit about it, but initially she said. And also, what we have from the post-conviction hearing, which is really from his attorney's, Mr. Randolph's letter to him, was that laid out some inconsistencies or difficulties with the proof for the defense, and which laid out, you said this, that you just pushed. The wife said otherwise. The medical examiner has a horrific long list of injuries the victim endured. In addition, you didn't report this, didn't provide aid, and you buried her body. It doesn't look good for you. The state will distinguish, and our position is trial counsel, he had two counsels. He had the initial counsel, it was about 8 months, and the second counsel. They both did separate investigations and communicated with each other about those investigations. They interviewed or attempted to interview individuals involved. They both went to the scene at different time frames, again, months apart. We don't have any detail beyond there were some trailers, but it's vague reference. The trial counsel that handled the trial matter all the way up to the plea created a trial notebook, filed motions, determined that a motion to suppress his statement would not be viable because of what occurred. Again, we don't have a statement. And then met with the defendant 10 to 15 times to review the case, to discuss the potential defenses. And yes, trial counsel said it's not a strong defense case. We don't have a lot to work with. But he also said repeatedly, I was prepared for trial. I was ready to go. I advised him against the trial. We went through, one of the trial counsel discussed in his letter and at the hearing that he was charged as first-degree murder because of a vulnerable adult. And the impact of the nature of her status as a vulnerable adult, plus the injuries she had incurred, and because his action otherwise, it would be a very difficult case. However, we also disagree with my friend on the other side that he didn't negotiate with the state. It's repeated throughout trial counsel's testimony that defendant, he was aware the defendant, when he took over the case, Mr. Randolph took over the case, that potentially the defendant wanted to plead to 20 years, or was willing to plead to 20 years. He addressed the state. The state did offer 20 years and gave a time frame what it had to be disposed of. I don't know if it was the court's time frame or the prosecutor's time frame. And that is clear from the record from trial counsel's testimony is that he went back and forth with the defendant and the state trying to negotiate to see if the defendant kept indicating maybe 10 to 15 years and the state wouldn't come off of it. In the end, the trial counsel cannot force the state to plead.
That was in the letter, wasn't it? Wasn't the letter, the language was, the offer's 20 years, it's got to be taken by X date, it's not getting any lower? Wasn't that the effect of it?
That's in the letter, and that letter was, I think, about the 13th, if I remember, of whatever month it was, and days later when they were in court, trial counsel still went and tried to negotiate again. There was back and forth attempts to negotiate, and trial counsel did what he could. And the end of the day, the defendant made a decision to enter the plea after looking at everything. And trial counsel did what he was supposed to do. And there's not the deficiency in his efforts to create a defense, to prepare for the matter, prepare for trial. Simply because trial counsel recommends not going to trial doesn't mean he's not prepared to go to trial. And so the defense clearly has not met its burden as to the any deficiency or any prejudice as to this. And then again, looking at the voluntariness of the plea, it's the state's position they've waived this matter. by failing to include the plea colloquy, because again, we do not know how the trial court addressed this matter at all. We don't know how the defendant responded. We don't know what the facts were presented. But at the end of the day, we do have in the record the plea colloquy, or the plea agreement, which goes through all the findings in regards to that. He said, I'm entering this freely and voluntarily. Actions are voluntary and not result of forced threats or promises of any nature. And the defendant signed it. So this is a very high burden for the defendant to overcome, the petitioner to overcome in this. And we'd ask this court to affirm the judgment of the post-conviction court and its denial of the post-conviction.
Thank you, General. Ms. Medor, did I say that correctly?
Yes.
Okay, great. You have rebuttal time, ma'am?
The only thing I want to say is I failed to ask for relief when I was up here a few minutes ago, and so we will ask that the court reverse the post-conviction court's ruling. Thank you.
Very well.
Thank you, ma'am.
Thank you all so much. I believe that concludes our docket, Madam Clerk. Okay, thank you all for being here today. Please drive safely on the way home. It's still dicey as we